Bangladesh, having this backdrop in consideration, is firmly determined to combat myriad of challenges in its pursuit of a robust, efficient, and accessible judiciary. With a huge burden of over 4 million cases pending in our courts, we are now focusing on the utilization of groundbreaking technological innovations in case management systems and addressing the increasing complexity of disputes in the digital age. Distinguished audience, amidst the crossroads of this evolving 21st century, as we are to extensively revisit our age-old understanding of rights, values, and connectivity, I am delighted to welcome you all to the International Conference on Judiciary Across the Borders. I extend my deepest gratitude to Honorable Chief Justice of Nepal, Mr. Bishwambar Srestha, and Mr. Justice Labjang Yarge, Honorable Justice of High Court of Bhutan, for graciously accepting my invitation and for gracing this conference with their esteemed presence. Their contributions will no doubt infuse dynamic vitality to our journey of building an effective knowledge-sharing forum to develop judiciaries that echo the voices of people and reflect the principles of justice, fairness, and inclusivity. I would also like to thank our chief guest, the Honorable Minister for Law, Justice and Parliamentary Affairs, Mr. Anisulok MP, for his valuable time today and also for his continuous cooperation. Let me begin my address by noting the historical context of Bangladesh-Bhutan-Nepal relationship. Over the past 50 years, through mutual respect, shared values, and moments of historic solidarity, the bond between these three nations has surpassed the mere setup of diplomatic connection. On December 6, 1971, during our liberation war, Bhutan became the first country in the world to recognize Bangladesh's independence. Nepal was also one of the first countries to recognize Bangladesh's sovereignty and independence after its liberation war in 1971. On January 16, 1972, Nepal officially recognized Bangladesh as an independent nation, leading to Pakistan breaking off relations with Nepal in retaliation. Respected audience, my esteemed colleague, Mr. Justice Labjang Yarge of the High Court of Bhutan delivered an exceptionally insightful and compelling speech on the people's judiciary in the 21st century. His eloquent speech and profound ideas left a lasting impression, motivating us to seek positive pathways. I strongly believe that the concept of people's judiciary envisions an institution dedicated to representing all citizens, including minorities, safeguarding their rights on an equal basis without discrimination, and fulfilling their fundamental needs as enshrined in the constitutions. This is a responsibility what we as judges take seriously, sometimes even at the cost of acting against prevailing popular sentiment, especially in protecting fundamental rights and liberal democratic values. Our commitment to uphold a just and equitable society cements the judiciary's status as a true people's institution. Courts, which have traditionally been regarded as national or domestic institutions, are now increasingly stepping onto the global stages. As remarkable and ironic as it seems, this phenomenon reflects a fundamental transformation in the judiciary's role worldwide. Courts now navigate a complex wave of international legal issues, demonstrating a dramatic evolution in their functional peripheries. National courts are now regularly confronted with intricate legal questions that transcend borders of nation-states. Disputes concerning foreign direct investment, intellectual property right, environmental concerns, international trade, human rights, mobility, and various commercial matters demand a true global perspective. National courts now not only interpret laws by referring to the precedents within their own legal tradition, but also draw insights from foreign jurisdictions and diverse philosophies that support just and equitable adjudication. Moreover, the 21st century presents a formidable array of complex legal issues due to societal shifts and evolving norms in a multipolar world. Thus, we need a radical assessment of traditional approaches to address critical issues of our times, such as gender equality, environmental sustainability, combating transnational organized crimes, and data security. As such, looking into the future, we must adapt best practices to our unique context. For this purpose, we may draw inspiration from the success of our regional and global counterparts. For instance, the e-courts project was conceptualized in India in 2005. India has established over 18,000 courts across the country with computer facilities, case information systems, and video conferencing capabilities. They are also planning to use online analytical processing and business intelligence tools to transform court process to advance significant reduction in case pendency and improved access to justice. In 2019, Japan introduced electronic filing, digital evidence submission, and remote participation in court hearings. Australia has also implemented a similar mechanism named e-courtroom system that is enabling lawyers and litigants to participate in hearings from distant locations. These initiatives have streamlined our court processes, reduced case duration, and improved satisfaction of litigants to a great extent. Respected audience, Bangladesh, having this backdrop in consideration, is firmly determined to combat myriad of challenges in its pursuit of a robust, efficient, and accessible judiciary. With a huge burden of over 4 million cases pending in our courts, we are now focusing on the utilization of groundbreaking technological innovations in case management systems and addressing the increasing complexity of disputes in the digital age. In this connection, I am pleased to say that as the guardian of the judiciary, the Supreme Court of Bangladesh has already made significant strides in judicial reform. During the COVID-19 pandemic, it seamlessly transitioned its operations into virtual proceedings, ensuring uninterrupted access to justice. Virtual courts across the country followed these footprints of Apex Court 2. The foundation of such unbelievable progress was laid by the use of information technology by the Courts Act 2020. The electronic filings of cases, virtual hearings, online cause lists, online accessibility of judgments and orders from Supreme Court and subordinate courts, and the use of digital evidence are now a timely reality for us. Moreover, the Supreme Court's initiatives for remote appearance of the accused and witnesses and the availability of English written judgments translated into Bangla have broken down barriers and ensured a more inclusive and accessible judiciary. But I believe this is just the beginning. We still have much progress to make in order to meet the demands of the people. In the meantime, the government has taken an initiative for introduction of e-judiciary in Bangladesh. The integration of artificial intelligence in the judiciary is no longer a distant future. In the courts of a number of countries, advanced AI algorithms have already been installed to tackle complex legal challenges and enhance the administration of justice. One notable example is the use of machine learning models to analyze vast amounts of legal data, including case law, statutes, and legal evidence. These AI systems can quickly identify relevant legal precedents, detect patterns, and provide valuable insights to help judges make more informed decisions on bail and sentencing. Some courts in other jurisdictions are using AI algorithms to assess the risk of recidivism in criminal cases, as well as to automate routine administrative tasks, such as scheduling hearings and generating court documents. However, it is important to approach the integration of AI with utmost caution, ensuring that it is used in a transparent, accountable, and ethical manner. Especially when it comes to the point of adjudication of disputes regardless of their nature. The final authority of decision must flow from human conscience, not from some machine-devised systems. It is so to make sure that justice, after all, remains a duty and task for us as humankind. Ladies and gentlemen, the judiciary of Bangladesh has proved its adaptability and commitment to human rights and constitutional principles in the face of 21st century challenges. Through innovative legal approaches, creative applications of legal doctrines, and consistent adherence to international human rights standards, it has ensured the continued protection of the people's fundamental rights and interests. Drawing on legal concepts such as the Datafin principle, the state action doctrine, and constitutional tort, the Apex Court of Bangladesh has successfully set precedent for extending the reach of constitutional protection beyond traditional state actors. But self-satisfaction is what we fear most. We know there is no ceiling set for improvement, no mark imprinted for perfection. As such, we have committed ourselves on a long-term judicial plan for the judiciary of Bangladesh. This comprehensive strategy will include the modernization of court infrastructure and the implementation of cutting-edge technology to streamline case management throughout the whole country. This plan would also cater for international collaboration, drawing on global best practices to strengthen our judicial system, and would help us to face upcoming challenges. Similarly, a part of our futuristic perspectives, the Supreme Court of Bangladesh is now fully prepared to establish a research and training institute in Cox's Bazar, which will provide high-tech, super modern facilities for judicial research, legal education, training for judges and lawyers, and pleasant lodging for researchers. Modeled after leading global judicial research institutes, it will be the first of its kind in Bangladesh. I would like to take the privilege of using this platform to express my deep gratitude from the core of my heart to the Honorable Prime Minister of the Government of People's Republic of Bangladesh, Her Excellency Sheikh Hasina, for providing us 7.90 acres of land in Cox's Bazar. We are grateful to our Honorable Prime Minister for her cooperation in these efforts geared towards realizing the broader vision of a smart judiciary for Bangladesh. Honorable participants, as the world becomes increasingly interconnected, the judiciary must evolve in step with these global transformations. By embracing the challenges of 21st century and fostering a truly global dialogue on justice, we can collectively pave way for a future where legal principles are upheld, human rights are safeguarded, and the rule of law prevails. Let us build partnerships with civil society organizations, academic institutions, and international experts to develop innovative solutions tailored to our unique needs. We must also invest in the capacity building of judges, lawyers, and court staff to ensure they possess the necessary skills and knowledge to navigate the evolving legal landscape. In our endeavors, we may also draw strength from the examples set by some Asian nations, including India, Singapore, and Malaysia, which have consistently ranked among the top nations for their respective judiciaries. We know actions speak louder than words. Every step, no matter how seemingly small or trivial, will bring us closer to our goal that we dream of, the dream of a just world, the dream of beautiful planet, the dream of human fraternity to bequeath to our generations to come. I know you have the ability, we have that courage, and we have that valor. I know we will succeed. We have to succeed. May the friendship among Bangladesh, Bhutan, and Nepal last forever. With their aspiration and dedication in perspective, let me conclude here. Thank you all. Joy Bangla, Joy Bangabandhu, Bangladesh, Unity.